I've known him as an acquaintance for probably 20, 25 years, I think. And his office, he works out of his home like I do. And his office is just very close to FIT, just north FIT, right?
Not far away at all.
All right.
Okay.
So, right here we go.
Okay, can everybody hear me?
Okay.
Yeah.
Okay. See where that is right there? Is that okay?
That is good. I have 20 minutes, so I'm on a strict time budget.
Absolutely.
And you said stay out of the weeds at all costs. Lawyers love wading into the weeds.
Because you guys don't get donuts until he finishes, so they're going to get restless at 19 minutes.
Well, I'm going to do this very quick, and I'm going to try to take some questions at the end, and I'll certainly be available for questions during the break. I'm glad Mary came up with me, because if you call or come by my office, the first person you're to come in contact with is Mary, unless our office cat Tiger beats her to it. We have a cat that loves to greet the clients. And Mary is also my very favorite wife. We have two sons, Gregory, who's 16, Kevin, who is 14. And I've been in practice here in Melbourne 23 years. And Jennifer's right. We have to start out with a joke. What's the difference between a catfish and a lawyer? Anybody know? One's a slimy, scum-sucking bottom dweller, and the other is a fish. Actually, one of the teenagers we work with in the youth group told me that, so we have lots of fun there. Anyway, I'm going to go through these things kind of quick because the clock is ticking. First of all, I want to talk about a will. You know, the will is the document that governs the disposition of a person's estate. A will, power of attorney, living will, designation, a healthcare surrogate is something that everybody needs. Like with a will, whether you're rich, poor, somewhere in between, you need a will. And the will names beneficiaries, obviously saying who gets what. Many times it is a general will where a person is saying all the rest, residue, and remainder is going to be divided up equally among my 4 children, or it can provide for specific bequests where it can say, I want to leave person X the sum of $5,000 or person Y my real property located at 123 Maple Street, Melbourne, Florida. But a will should be drafted clearly, and there should be also a personal representative appointed. A personal representative is the person who oversees the estate, makes sure that everything is settled, everything is processed, that everything is paid. Other places often call that person an executor or an executrix. Florida, we use the term personal representative. It means the same thing. And people will sometimes move to Florida and will say, well, I've got a will from New York. Is that will good in Florida? Not necessarily. These documents are very state specific. And it's important to have Florida documents that work here in Florida. And Florida, for a will to be valid, has to be signed by the testator, the creator of the will, witnessed by 2 people, and notarized. And it has to be in a certain format, certain language. And many times people think, well, if they want to make a change to their will, all they have to do is take a pen and cross things out or write extra sentences in and put their initials by it. Not only is that invalid, but that essentially invalidates the whole will. The problem is when people write or cross out on their wills, the basic problem is those witnesses and that notary were not there to see the person make the change. So Florida law has to well conclude that that may well be a disgruntled beneficiary messing with the will. So Florida, because we have a lot of retirees, is very protective and very particular for good reason when it comes to these documents. So if somebody wants to change their will, the easiest thing to do is just have them sign a new will. Hence, it's the last will and testament, the last valid will that controls the situation. It is possible to amend an old will through a codicil. A codicil is an amendment to the will, but it has to be executed in all the same formalities as the will. I find that the easiest thing to do is just sign a new will. Keep things, because when you do estate planning, you want to keep things as simple and as straightforward as possible. Lawyers love complicated things because they get to spend more time unwinding the ball of yarn and more time where they can charge for their time. So my advice is keep it simple and straightforward whenever possible. And with a will, it is possible to have what is called a separate writing. This is a change in the law a few years back that allows that when a person has items of tangible personal property, personal effects, instead of years ago when I started out, we had to write it in the body of the will, you know, who got the tea set, who got the golf club set. Now it is possible to do that on a separate sheet of paper, very much like a letter of instruction, where a person can list personal items and say who gets what item. They only have to sign their name at the bottom of the page. They could have one page, they could have 5 pages, as long as they sign their name at the bottom of each page. And those separate writings do not have to be witnessed or notarized. And the beauty of the separate writing is that if somebody fills one out, 6 months later, they want to do something different, they can throw it away, fill out another sheet, sign their name at the bottom. It's done. It's very short and sweet. One thing that is important to keep in mind with the will is that there are certain assets that are not controlled by a will. For example, jointly held assets. If a person holds a bank account or a brokerage account where they're holding it in joint names, there is a presumption of a right of survivorship. I had a lady who passed away not all that long ago. She had a will, and in her will she said, everything in my estate is to be divided equally among my 3 children. Well, before she passed away, it turned out that on 2 of her large financial accounts, she added her oldest daughter's name to the accounts as co-owners, which meant that when mom died, those 2 large accounts went by right of survivorship to the oldest daughter, which meant that the daughter received that outright, and she was under no legal obligation to share that with her siblings because she took those 2 accounts out of the control of the will. Also, other assets, such as retirement accounts like IRAs, 401ks, because those are set up in their own trust or custodial-like arrangements, you are able to name direct beneficiaries on those accounts, and whoever is named as beneficiary or beneficiaries, upon death, the remaining monies is paid out to the named beneficiaries. Same is true with life insurance or annuity products or other life insurance products. Whoever is named as the beneficiary or beneficiaries, that's how it pays out. And it is important to remember that the will does not come in and override or supersede a direct beneficiary designation. Instead, you have to think of the will as being a catch-all to what is left over. Quick example, I had a guy that came to me a while back and he said, Len, I want you to draw up a will and I want to leave 10% of everything to my church. Okay, great. I said, I can definitely do that. But understand, the will doesn't control all of your assets because he had a 401k, he was an engineer, he had some life insurance and so forth. And as a result, if I just drew up a will saying, okay, 10% goes to his church, that would not include the 401k and it would not include his life insurance money. So to make a long story short, what we did there is he ended up and had what he wanted, the equivalent to go to his church, come out of his retirement plan because that was pre-tax money. So it was kind of a win-win situation because by doing a little bit of planning, and certainly the financial planner that's following after the break and probably get more into matters about the financial and tax planning, but he was able to leave the church money directly out of his 401k, which meant that if he had left it to, say, an individual, well, they would have had to pay income taxes on the IRA because it's tax deferred or pre-tax. But because it went to a nonprofit organization such as a church, the church got the full amount. The only loser in that event was the IRS. So a little bit of planning goes a long way. Okay, so that is the will. Then we get into a power of attorney. Very important document to have in place. And a power of attorney is created by the principal. The principal is the creator who is the grantor or the giver of the power of attorney. They give power of attorney to what it's called an agent or the attorney in fact. That could be, a spouse, it could be a child, it could be a trusted friend, or it could be an elder care specialist such as Rob, where under a power of attorney, they have the ability to act on behalf of the principal and handle their legal and financial matters. The main attraction with a power of attorney is that it will avoid a guardianship proceeding through the courts. And a guardianship proceeding, it's a very lengthy, ongoing, involved, often expensive proceeding where you're having to get court permission to basically do anything on behalf of the person, on behalf of the ward. The way to get around that is to have a valid power of attorney in place. And the way it works in Florida is that the power of attorney is good from the time that the principal executes the power of attorney, and it remains in effect until either the principal dies or revokes the power of attorney. So it does lapse at death. In some respects, it's a mere opposite of a will, because a will has no legal effect while the person is alive. It's only after they pass away. But the power of attorney is fully revocable. That is the good news, so nothing is etched in stone. And I've had many people who have, they've given their girlfriend or their next door neighbor or some relative power of attorney, and they decide down the road for whatever reason they don't want that person to have power of attorney anymore. They can execute a revocation of that power of attorney, dissolve it immediately. And with the power of attorney, probably the biggest question I'm asked is people will say, Len, now if I sign a power of attorney, am I giving up any of my rights? And the answer to that is no, because what is not happening with the power of attorney, the person is not saying, I hereby give and transfer my rights to so-and-so, but instead you have to think of the power of attorney as being a coextensive extension of a right, where the person is saying, this individual, in addition to myself, can act on my behalf. And I have many people who have a power of attorney in place who are well into their 90s and they're doing very well, but they enjoy having the power of attorney in place because if they have a situation, say at the bank, they can say to their son or daughter who has power of attorney and say, you know what, I don't feel like going down to the bank and taking care of that. Can you go down and take care of that for me? They can do it. And certainly a power of attorney is in place if a person is incapacitated. And because otherwise, if there's no power of attorney in place, and let's say a parent is incapacitated and that son or daughter tries to do things on their behalf, they're going to run into a brick wall because they have no legal authority. Their only other option then is to hire a lawyer, go to court on what is called a plenary guardianship, and have to go through the full 9 yards of guardianship proceedings. So having a power of attorney in place solves many problems. And also, powers of attorney, especially in the last couple of years here in Florida, have become very specific. It used to be we could write a power of attorney and say, I hereby give John Smith power of attorney. They can do the following acts and kind of give a general laundry list of what they can do with the power of attorney. That's basically all gone by the wayside. Now it has to be pled with great specificity. It has to refer, for example, to Florida's banking transaction statute, to Florida's investment transaction statute. And if these things aren't in it, these institutions don't have to honor the power of attorney. And this is the problem that we run in, where people will come in and they say, well, I've got a power of attorney from Michigan. Well, can't I use my power of attorney here in Florida? It doesn't work that way, because an out-of-state power of attorney, they're not going to have the foresight to say, well, hey, this person might move to Florida. We better have all these Florida state-specific things in the power of attorney. And so we run into this problem with LegalZoom. People are like, well, I can get documents on LegalZoom. The problem is they try to make their documents legal in 50 states and they end up really not legal hardly anywhere because of that. And people will say, hey, you're a lawyer, you're just looking out for yourself and other lawyers. Well, the truth is, I want to make sure people have these documents in place, because the time to find out that your documents don't fly is not when a person is incapacitated and you have family members trying to act on your behalf. The truth is, when people come to me, and if they don't have the money, I have done plenty of work at a reduced rate, or I've done plenty of pro bono. I don't say that to pat myself on the back, but I want to be able to sleep good at night, know that I have done my best and that I have served the best interest of people. And I want to make sure that they have these documents in place, because an ounce of prevention is worth a pound of cure.